April 2019. At this point, I would invite you to join us in a silent moment of prayer, followed immediately by the oath of allegiance to the flag of our country.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Yeah, I'm going to do business. Beth, may I have a roll call, please?
Yes, members Clymer, Foyle, Voss, Pryor,
Here.
Weeks,
Here.
Mayor Nangucci,
Here.
Vice Chairman Fishbach,
Here.
Chairman Van Lee,
Here.
Lippert.
Here.
Sign right now.
Thank you. I guess we'll move right on to old business. The first item under that is to approve the minutes of the February 27th, 2019 meeting. Has everyone received a copy of that?
Yes.
Are there any comments, questions? Hearing none, I'll entertain a motion to approve the minutes.
So moved.
All those in favor?
Aye.
Aye. Opposed?
I have to abstain.
Okay. Note that, please, Beth. Any objections? Okay, minutes are approved. Next order of business is Sampson Enterprises LLC, Block 95, Lot 11.03 for complete. Is the applicant here?
Yes,
I assume they are. Good evening.
Chairman Randall. I'm William Mandry. I represent Robert Sampson and Sampson Excavation. We're here for a review for completeness, requesting several waivers, and after extensive review with the engineers, I'm sure they'll go through all the details. But just a gentle comment on the issue of waivers. A waiver is really basically what is reasonable under the circumstances. So we just ask your consideration for a waiver on the traffic study. It's something that my client can testify to as to the number of vehicles that go there. I personally know that roadway. I live 1/8 of a mile away, travel it 3 times a day. You know, it's, and I know from your personal experience from knowing the area, I just would respectfully request you take into consideration the waiver of that requirement for that traffic study. All the technical specs for the preliminary site plan checklist and for the final site plan checklist have been basically worked out by the engineers. We're willing to comply with whatever is required of us. Maybe it isn't done today, but you have the authority to deem the application complete with a promise that we'll make sure that everything is satisfactorily taken care of. So with that, I turn the matter over. This is my client and Greg
Vanderite.
I can never get that right. Greg Vanderite.
Everybody screws up mine. It's my last name, so it seems like it would be easy, but it's not.
So that's my general presentation, Mr. Chairman.
Thank you
How
very
would
much.
you like us to proceed then?
Absolutely.
Okay.
Oh,
All right. Greg,
I think, basically, I think the only, and I've been having conversations with Paul over the past week, and we had a extensive list of deficiencies from the initial submission in which we addressed. There was a couple of minor issues that Paul pointed out that still remain as a deficiency, which are spot grades and dimensions around the perimeter of the building and the perimeter of the parking lot. Those were on the plans. They must have got turned off in a layer when we plotted, so all we got to do is turn those layers back on. And then also, Paul was looking for some additional details. We have a small retaining wall to allow us to get some sight distance at the driveway entrance. We provided some additional information, but I guess it wasn't what Paul was looking for. But we'll coordinate that with Paul and Adam when we go into the technical aspect of the project and technical review of the project. Again, we're asking for a a waiver for completeness only for location of trees over 9 inches. Most of that site is a lot of scrub. There's not many mature specimen trees on the site, but we will locate them. And then the last remaining completeness waiver we're seeking that Bill mentioned was the requirement of preparing a full-blown traffic report due to the very, very limited amount of traffic that Mr. Sampson's application and project is going to bring to the roadway to Bellevue Ave. As you know, Bellevue Ave is a very skinny road. It's not very heavily traveled, especially during the peak hours of, which is why we're asking for the waiver. He basically has 3 employees. One stays there for the entire day, and Bob and his other operator are in and out in the morning or evenings with machines, but they're not always coming back to the facility at evening after the day is over with. Basically, sometimes they will take a machine and they will go from one project and just move the machinery to the next project, so they're not even coming back. So we're, it's a rather large expense. We don't think that it's really necessary to have to prepare a traffic for something that generates as little traffic as
I have
this
a quick
project
question
will.
for Mr. Sampson, if I'm along those lines.
Sure.
And you're familiar with the operations. Is it just primarily employees that come and go, or do you have clients and customers?
It's just employees, like he said. We have one secretary, and it's me and another fella. There's 2 dump trucks. Sometimes the dump trucks don't leave. The equipment, like he said, sometimes we move it. We like to move it from job to job to job. We don't like transporting it too much.
But it's not like a retail operation where
No.
customers are coming in.
It's not a trucking outfit. It's not a retail operation. It's just a small
Bob, you
construction.
meet people on site and by email and communication through the telephone?
Yeah, that's mainly.
We never swore Mr. Sampson.
It's not a hearing, it's just for completeness.
Just for completeness? Okay.
Yep.
Okay.
I'm okay, yeah.
Okay. Let me call on Adam first. If you have any questions with the waivers or anything like that?
Sure, specifically, I mean, just to address the traffic study, we understand that it is a low traffic generator as far as the use is concerned, so we would be, given the testimony provided today, and then, just touch on that testimony during the formal hearing for the application, we'd be supportive of waiving that, at the board's pleasure, of course. And I believe, if there were, I'm just checking if there were any other waivers requested. I'm sorry? Sorry. Sorry about that. No, that's fine. I'd say number 1 here is against. Yeah. So yes, as was touched on by Mr. Mandry and Mr. Vanderride, the previous deficiencies were addressed, so we really had no other comments, and we were supportive of the other waivers or not applicable designations that were requested, specifically off-site any locations and dimensions of off-site loading areas and within 100 feet of the site, which don't exist. Lands to be dedicated to the township or county, none of that's not applicable, of course. Open space uses, not applicable. Stages of development, I'm understanding this is all going to be built in one phase. There's not going to be multiple stages. And then wetlands, which are not present on the site per DEP and Highlands mapping. So otherwise, I mean, we're supportive of and then the other technical deficiencies which were touched on, those will be addressed during a technical review and then during resolution compliance to make sure that, the information that's needed for construction and to confirm compliance with either ADA requirements or any other building code related items will be provided on plans.
Correct. Yes, we will work with you with getting all those technical items ironed out.
Correct. So that's all we had.
Okay. George, do you have anything?
No, my letter dealt with things that did not relate to completeness.
Okay,
So
very good.
I'm very comfortable with deeming them complete at this time.
Okay. One question I have, is there any involvement with the Highlands on this? That you got a letter of...
Yes,
or
the Highlands,
expectation?
yes, the Highlands did issue a consistency determination for the
Okay.
project. There were a number of conditions which they typically do impose on projects when they grant these consistency determinations, specified conditions they list. And those are typically handled during resolution compliance. As part of the township's obligation to the Highlands, any of their conditions have to be addressed during resolution compliance.
Okay.
And so things like providing the landscaping plan and meeting the Highlands requirements for landscaping, for any of the screening landscapings that might be required per ordinance, protecting forested areas. So that's just going to be a matter of, addressing during construction and showing on the plans. And then the geotechnical investigation, which was provided by the applicant. So, anything else that the Highlands requires, we'll handle during resolution compliance.
I just wanted to get it on the record that the Highlands...
Correct, yes.
We met with the Highlands Council, we met with Carrie Green, and she seemed very supportive of the plan that we presented to her. She wanted us to move some landscaping and change around a few species, use some different species of plantings as opposed to what we had proposed, which we're perfectly fine with doing.
What about the overall height of that building? The overall height of that building is 26 feet 8 inches, is that correct?
I'd have to check there. Yeah, there were some preliminary building plans provided.
4,800 square feet and 2,400 square feet office.
Right, so it's 7,600 square feet of...
I think the mayor was asking for height.
Yeah, the height.
Building height?
The actual height
Yes,
of the
I
building.
think it's...
Appears to be 26.8.
For some reason, 22 sticks in my head if I took the slope of the roof.
That's 16 feet is from the finished floor to the bottom cord of the trusses.
Right,
The ridge
16
is
to the bottom
26.
cord.
Yeah. And
Yeah, so 26 feet. 26.8.
it's within the code.
It's within the code.
Yeah.
I think it's 35 feet
Right.
in the code.
That's what I was after.
Yes,
Fine.
okay.
And there are no variances requested.
No. I don't think, George didn't identify any,
question?
I don't believe.
So it's a clean application.
Please don't.
Clean application.
Anyone else have any questions?
Yeah, I think it'll be a-
In
it'll
that
be
case, I'll entertain a
improvement.
motion to deem the application complete, grant them the waivers that they have requested, that's approved by our engineer. Do I hear a second, or do I hear a motion? We have a motion, do I hear a second?
I'll second it.
Beth, roll call, please.
Yes. Members Quayle? Yes. DeVos? Yes. Pryor?
Yes.
Weeks?
Yes.
Mayor Mengucci?
Yes.
Vice Chairman Fishback?
Yes.
Chairman Van Lee?
Yes. Okay,
Thank you, folks.
Thank you. Have you enjoyed
good
the
luck
rest
with
of
your
the evening?
project.
Thank you. Thanks, Bob.
See you next month.
Okay.
Thank you, Mr. Chairman. And Mr. Chairman.
Okay, that completes the whole business. We're going to move on to new business, Architects Golf Club, again for completeness. Mr. Peck?
Thank you, Mr. Chairman, members of the board. For the record, my name is Mark Peck. I'm an attorney with the Florio Prucci Law Firm here on the behalf of Lawrence Turco, who operates Architects Golf Club, that large red area on the map over there. 700 Strikers Road, Lot 29 and Block 95. 177-acre tract in your R3/2 zone district. We have an application pending for minor site plan. We're here tonight for completeness review. We did have the chance to look over both the Mazer and Mr. Ritter's review memos. I'd like to quickly go through the Mazer review memo first. That identified some deficiencies with our submission, specifically various plan revisions to show the title that it's a minor site plan, to have signature blocks, names and addresses, zoning table, lot dimensions, a revised plan, plus certain notes to be added on the plan. A revised plan has actually been submitted earlier this afternoon that we believe is fully conforming, notwithstanding the Mazer review did indicate that it was appropriate to grant a waiver for completeness purposes. So to the extent that our revised submission doesn't meet these deficiencies, certainly we will, if we're fortunate enough to get an approval at the end of the day and submit our final plans. So we're hoping the board is good with those. We also are seeking one waiver. And this is where the 177-acre tract size comes in. This is from item 15 on your checklist, which requires us to show the location of the proposed construction and all existing structures, roads, utilities, etc., within 200 feet of the site. You know, we have a 177-acre site. We're looking to install a 640-square-foot modular building. In the interior of the site, we believe we've submitted certainly enough for the board to make a sound, reasoned determination of this minor site plan application, and that this would not do anything further to enhance the board's understanding of this application. So we do respectfully request a waiver from that provision. So that would complete basically my discussion of the Mazur review. More interesting is George Ritter's review. It's important to note that the pro shop, because that's what this building will be, it'll be a pro shop. It's an accessory use to a golf course, even though it's not specifically listed as a permitted accessory use, nor is it listed as a prohibited accessory use. I think common sense would dictate that a golfing pro shop is accessory to a golf course use. It's going to be 166.9 feet from the street. Now, your bulk regulations at section 66 C2D states that any golfing facility or maintenance structure shall be situated 75 feet from all property lines. The clubhouse and dining facilities shall be set back 400 feet from any street. Now, Mr. Ritter, obviously he's a great planner. I've never really had cause to disagree with him before. In this instance, I'm going to. He suggests that a variance is necessary, and I believe that to be because, well, I'm guessing at Mr. Ritter's reasoning here, but pro shops aren't listed as an accessory use. And you have, so he bundled that into a golf use or clubhouse use, I guess, as opposed to being a maintenance use. Now, the ordinance specifically says that a clubhouse and dining facilities have to be 400 feet from the street. But then it says, and it's pretty clear that our proposed pro shop is not a clubhouse and it's not a dining facility. I think we can all agree on that. So what is it? Is it a maintenance structure? No. We can cross that one off the list. Is it a golfing facility? Yes, I would say it is. Or is it another structure? I would also say clearly yes. That's a very broad definition. And I have to ask whether drafters of the ordinance would specify, clubhouse and dining facility to be 400 feet away, but then have this other category of golfing facility that could be 75 feet away. The ordinance isn't clear, and it's clearly up to the board, but we think that this 640-square-foot pro shop would be a golfing facility that would require a minimum setback of 75 feet, which we meet. Therefore, we don't need a variance. But again, it's up to the board, obviously. So that's my pitch.
Well, I think I probably have to respond at least to help the board think about this a little bit. Essentially, the determination that I made at looking at this is that your ordinance makes a distinction between what I call the public side of the golf course, the pro shop, the restaurants, and the maintenance and facilities side of the golf course. And the public side, the clubhouse, the types of uses that go in the clubhouse, that could be a pro shop, it could be, truthfully, it could be detached from the clubhouse, to me was the public side, and the ordinance seemed to think that those things ought to be set 400 feet from the street. Things like maintenance sheds, types of things that go with the golf course itself, was where the 75 feet applied. So my general sense is that this would be a C variance for setback. Obviously, it's an accessory use and would be permitted, but it is clearly not the same as a golf maintenance yard and that type of thing, and the 75 feet would not be applicable to it. So that's the distinction that I made, that normally this type of use would be seen as part of the golf club activities, the public side, and would be subject to the 400-foot setback. And that's how I came to the conclusion that this does require a C variance for setback.
And if I may, just respectfully, as far as I read your ordinance, it does not make a distinction between public uses and and private uses or other uses. Public use, I believe, is mentioned at all in the ordinance, but the ordinance does specifically say, it sets aside a clubhouse and dining facilities. Pro Shop is not a clubhouse, it's a separate building from the clubhouse, and it does, in the bulk standards, it has 3 categories that should be situated 75 feet from all property lines. Any golfing facility, maintenance structure, or other structure. So it's not just limited to, non-public uses that can be 75 feet away. I would say a golfing facility by, implicitly would be a public type facility. So respectfully, I disagree with George. Respect his reasoning, but, I think on this one, we have a stronger argument.
So I have this clear in my head. That modular building they went for was 277 feet from the road?
It would be 166.9.
166.9.
Feet from the
And any of the maintenance facilities out there can be just 75 feet?
75 feet from the facility, from the apartment.
What I'm driving at there is I think there would be more noise coming out of that maintenance shed 75 feet off the road than there would be that modular.
I don't disagree with that. It's just an ordinance, and again, this is a call for the board. The ordinance, I think, was trying to make a distinction the types of activities that take place, and I call it the public side, but it's the side where the golfers interact. They basically have the restaurant, they have their clubhouse. Normally, you'd tend to think of the pro shop being associated with the clubhouse, or at least sitting close to the clubhouse. And so that type of use, I thought, was governed with the 400-foot setback. And things like tees, greens, the maintenance facilities. In fact, the ordinance, in terms of the driving range, it made it very clear they didn't want any of those covered within the, if you read it, they were concerned that you not get structures within that 400 foot. They were talking about that for covering the driving range facilities. But that aside, the main distinction I had was that normally you would think of a clubhouse, the pro shop as being part of the clubhouse facility, and therefore it would be governed under the 400 feet. And I think what we're doing here is that the use is permitted, we're really just saying it needs and the board may consider it appropriate, would require a setback variance. That's my logic behind it, and the board obviously can make their call on that.
To you for the legal opinion.
I'm going to say something that not necessarily is specifically a legal opinion, but this becomes really technical jurisdictional issue. As somewhat discussed here tonight, without getting into merits and presuming what the board's action may or may not be, certainly there's a significant setback here for what's being proposed that is more than 75 feet, but technically less than 400. And avoiding the debate, it may just be appropriate to notice for that, and to the extent that the board deliberates on it, it may want to grant a variance so that if it was ever challenged by any type of third party, they can't say that you needed a variance and you didn't get one. And not necessarily that this board is the proper jurisdiction to determine the interpretation of a code. It's technically not. I think that we defer to George on this. It's a suspicion, again, I don't want to presume. I think from a technical perspective, it's safer to notice for the variance, to apply for that variance. It does not change the nature of the minor site plan application. It's still a minor site plan. And the board would be in a position then to say, looking at this, and again, I don't want to presume that it is set back sufficiently as to avoid any of the concerns that the ordinance was trying to avoid. So I think from a technical perspective, it's appropriate to allow for the notice of variance, proceed on that ground to the extent that it may be required.
Okay.
The old belt and suspenders approach, huh?
That's correct, yes. I call it the conservative approach. That's what I call it.
Yeah, it probably is conservative, but it's hard to argue against George's logic. It's hard to argue against Mr. Price's opinion. And it is the safe route. We've been to court before on stuff. There's no reason why this can't be, the variance can't be part of the application. So I'd be in favor of classifying it as a variance.
Okay. Any other comments?
Yeah, I would agree with that.
I myself would err on the side of caution variance. I know it's going to be requiring notice to the surrounding property owners.
I'm just hoping that given the sort of, I don't want to deem it trivial, nothing in land use is really trivial, but the minor nature of it, that, you know, we're not burdened with the expense of having to bring a planner in to talk about the impacts of a 640 square foot building 167 feet off the property line.
You know,
I know we have to put on our proofs, but I think the testimony...
A pro shop, like, as stated, is, a lot of times is within the clubhouse. Right?
Yeah, no, I get it.
But I've seen them detached also. But I can see, you know, I can see your concern in that, but again, I don't see any more traffic than would be there normally with golfers, because normally that's who's going to use the pro shop, right?
I think people are going to make a destination solely to the pro shop. I think it's,
And you
know,
probably have more
connection
public
with the
usage from the outside, just using the restaurant and the bar,
Yeah.
quite honestly, right? Than, quite honestly, the pro shop.
Counselor, I think that your client would be more than qualified to talk about how this property
Put on the
is set up,
proofs.
what's being proposed, why it's being proposed where it is. Certainly that's within his ability.
Great. That's really our main concern. It's just, you know, start larding it up with professionals, it's, you know. No.
This is a temporary facility?
I don't know that we're going to take testimony, but yeah, that's the plan. This is temporary in the context of the larger overhaul that you guys will probably be seeing. You know, I don't want to promise any time frame, but that's under discussion. So this is merely a holding pattern to give the golfers, you know, an amenity while the larger improvements are being contemplated.
So you don't have a time frame?
No, not yet. I just know there's been discussions about the other one. I'm not privy to.
Can I speak? Can I add something, possibly?
Sure.
So I have to be sworn in, or?
No, it's not.
This is just a completeness hearing. We're not really taking testimony as to the merits of
Thank
the
you for
case.
everyone's time. I appreciate you guys, short notice, having, seeing us. I'd like to give you a opinion from a business standpoint. We got it from a technical standpoint, we got it from a legal standpoint, we got it from a planning standpoint, we got it from an engineering standpoint. Now we're going to talk about it from a business standpoint.
Mr. Turco, would you mind coming up and speaking into the mic?
Yeah, just for the record, identify yourself.
I'm Larry Turco, Architects Golf Club. It's a temporary facility. We have a 2-year lease, okay, with a 6-month extension. Based on my interpretation of the code, I feel strongly that it doesn't need a variance. It's very clear the way it's written, and if someone reads through it, it's very clear. So in my opinion, that it's not necessary. I've spent, for this trailer, thousands of dollars. Thousands. It's unacceptable. It's a temporary facility. It's there for the benefit of the golf course. It's almost $10,000 already. Now, I'm gonna go for a variance. How many more thousands am I gonna spend? You know the situation with the taxes. I paid $205,000 the last couple of weeks. Okay, I'm trying to just carry through with the bad weather we had the last couple of years. We have a lot of pride and respect for the town. We've never had any violations. We take care of that place like it's my third child. And I just hope that I have some consideration here because it's a financial impact. And another variance is another thousands of dollars, more reviews, and it's just not affordable right now. So from a business standpoint, I'd like it to be considered, it's a temporary facility. So who's going to challenge a temporary facility when it's not even going to be mounted? It's going to be slid onto the ground. It's going to be leveled. There's no excavation. We've made ADA ramps already. It's all prepared. We have everything laid out. It's going to have a air conditioner already installed. There's not going to be any construction. We're going to hook up power
and we're in business. And it's only there because we built a sports bar, because we have an issue with fortunately, we have a very good catering business, so we wanted to make sure that we can, chew gum and walk at the same time. And the golfers were taken care of, full-time with a restaurant. So we decided to spend, it's gonna cost me $1,400 a month for the lease, okay? So we're adding $1,400 more a month, $10,000 in fees, the temporary facility. We want to see if it's gonna work. If it works, then we're gonna put a small addition on the building, so it'll be part of the building. So I just respectfully appreciate everyone's time, but we need to look at this from a business standpoint too.
Just so we can clarify, it seemed that the board, and I understand expenses are concerned, I know I'm a big driver to that, so I certainly.
Well, no, it was more than that.
But the board did indicate that we wouldn't have to hire like a planner. Your testimony would be sufficient for the proofs. I mean, it's a pain, we're gonna have to pay the notice, send letters out, put it in the newspaper, but other than that, we'll be back next month and do what we gotta do. And I think the board will be, I think the work will be.
Okay, thank you.
Let me just ask this. You're saying it's temporary, and then just to see how it's going to go. And then after that, you're going to build something else?
Well, right now, what we did is, the reason why we could have made it downstairs, but the flow of the operation doesn't work. So it's gonna be, all they're doing is checking in there. There's no bathrooms. They're checking in, and then everything, they're gonna go play golf. It's gonna be there for only 2 years, because we plan on putting a small addition on, okay? So the whole left side of the building is gonna basically be for golf, okay? And then the right side of the building is gonna be for catering and, for events.
And that would be the subject of a different planning board application. It's not like we get, this isn't the camel's nose poking under the tent,
No, we're gonna have to go for a plan. But there's other things coming down the road too, which you guys are aware of. I went to speak to a few months ago, so any considerations, just that right now, the timing of this is very, very critical. It's showtime right now. We had 2 weeks of 2 years of very bad rain. So if this is gonna go another 2 months, it's gonna really impact, it's gonna have a monetary impact on my operation. Because right now I have them temporarily checking in into this beautiful clubhouse in the front. I have 200 people weddings coming in, and there's people checking in the breezeway. It's just not working for us right now.
So there's no pro shop currently in
No.
the clubhouse? Okay.
So there's some issues. So any considerations greatly appreciated.
I'd like to ask him, could have been here. What made you choose that area? Could have been here.
Because the location of that area is critical for the flow of the operation, and the first tee's right there. And so
We're not taking testimony right now.
This isn't involving anyone here.
Let's go. We're here for completeness of various issues.
I just thought we were getting there, so.
Nothing that you said really is going to be considered by the board on the merits. It's just kind of informing the board as to the nature of the applications.
So, I forget with all the excitement, was your vote that we're complete?
Well, it's still a vote for completeness. We understand that the notice for the variance that was identified for a jurisdictional issue.
I'd ask, is the application incomplete if it doesn't include the variance?
Yeah, the application has to include the
It has to
variance, which
include
is,
the variance.
that's an
Yes.
administrative
All right.
issue that is simply addressed. I don't even think that the plans really need to be revised for that, because the dimensions there, we know what we're talking about. The only thing that would be required with the actual submission of a physical piece of paper would be that it would have to be published in the paper in a 200-foot list. It noticed to the surrounding property owners. It's not that large of a administrative burden. I don't know how many property owners, looking at the map, I don't,
Not gonna touch that many, because just look at the footage from there to the street, you're almost there. You go across the street, you might even be, it might be just that house that's actually directly across.
I don't want to pretend to know how many.
Yeah, that striker's frontage goes a long way. A lot of
It's
residences on the other
property
side.
lines, so it's a lot of...
Yeah, it's from the property line,
Yeah,
not from the
right,
proposed
right.
structure.
No, I know, right.
I just don't see it as an issue. I think I've had conversations with Mr. Turco. He's had has a bar in his main banquet room, and that's where his golfers went. If there was a banquet there, the golfers were kind of chased away. So he has seen fit to give his golfers a place to go have something to eat and something to drink. away from the main banquet room so that he can have a banquet in there without any interruption. So I think it's a good business move from his standpoint, and, quite frankly,
Is that what this facility will do? That's what will happen in this trailer? The golfers would go there to eat and...
No, there's some...
Okay.
There's a sports bar
Check-in.
that they'll use for that.
Okay,
That'll
so it's-
segregate them from the
so it's just
weddings
gonna be
and...
for check-in, buy shirts,
You-
stuff
you
like
need-
that.
you need your
to use.
balls.
Just what a pro shop exactly
Just to
is.
check in.
Right.
You're not going to be selling anything?
Pardon me?
You're not going to be selling any clothes, shirts,
Well,
balls?
there's going to be some, but it's
Not a lot.
it's a 600 square foot building.
Right.
So this is just a gathering place, basically, sounds like.
No,
Simply to sign in.
Start up.
You got to check in.
Again, we're here for completeness,
So you
just to
gotta pay
remind
and
the board
go
that we're just here for completeness moving forward. It's established that they're going to be applying for a variance, at least cautionarily, to make sure that we have jurisdiction and it's proper. And then there's completeness issues that have to be addressed. And then if the board determines it's complete, they'll be back for the merits.
Can I ask a question?
Certainly.
I'm looking at the latest taxes, and they show unpaid as of 4/24 for the first quarter taxes and the sewer.
I know there's a substantial payment made, and I believe that was sufficient under the circumstances to move forward. We did get the certification.
Here's what the law is when it comes to taxes paid and the board's jurisdiction. And this, I actually answered this. I'm actually just going to recite what I said in an email. Our section 243-29A4 does require proof of payment for an application, and that's a submission requirement for completeness. The statute requires proof of payment for an approval of an application, which is different from making an application. It's for the approval application. Because under Lopatcong's ordinance, proof of payment is a completeness requirement. The applicant is allowed to seek a submission waiver, which can be granted by the board for good cause, but any approval that may be issued by the board will be strictly conditioned upon the payment of taxes before they can get any type of permit. So it's the board's prerogative whether or not to grant the submission waiver for the payment of taxes. It's certainly within the ability of the board to do that, but the board's not saying you don't have to pay taxes. It would just be for the matter of hearing the application, but any approval would be strictly conditioned upon the payment and tendering of taxes payments and whatever else is required by law. So I think that's certainly within the board's ability to do. And you certainly don't want to be arbitrary and say, now we're not going to hear you, just because you didn't pay taxes. That can be troublesome as well, so.
Yeah, we just can't get a CO until
That's
they're
correct.
paid up.
Yeah, it's not an insignificant amount, it's 242 from what I've seen, but the law protects us going forward.
Yes, and the resolution would protect you as well.
I certainly have no objection to, hearing the application, and relying on the law.
So it comes down to calling for a motion to approve it.
Deem it
but
complete.
Deem it complete on the condition that they notice and come back for it, correct?
That's right, and grant the waivers as requested.
Do I hear a motion from that?
Motion.
The first motion is what, to deem it complete
Based on
based on a variance being required?
Complete.
Well, it's
The variance
deeming
needs to be
complete, variance required for
without a
notice.
waiver.
And the waivers, to the extent for submission waivers, will be granted.
I'm sorry, one more time, what the
Yeah, I gotta have that
Yeah.
clear said.
It would be a motion to deem the application complete.
Yes.
Granting the submission waivers as required, with
Right.
the understanding that they're going to be proceeding to provide notice for the variance identified by the township planner.
All right, Tom, is that the motion you made?
That's it, yep.
I'll second his motion.
Yeah.
That's roll call vote, please.
Okay. Members Coyle? Yes. Ross? Yes. Fire?
Yes.
Weeks?
No.
Mayor Mangucci?
Yes.
Vice Chairman Fishback?
Yes.
Chairman Van Vliet?
Yes.
And, excuse me, Beth, when's the next hearing?
It'll be May,
22nd,
it'll be the fourth Wednesday, is that what you see?
I believe it's...
22?
Yeah,
Yep, 22.
22nd.
All right, very good. Thank you very much.
Thank you.
See you next month.
Good night.
Okay, that completes our new business. We'll be moving on to board business. Going to turn to Mr. Ritter for the Highlands mapping and groundwater discharge. Would you bring us up to date on
Yes.
what's going on?
If you'll recall, at the last meeting, we basically introduced the map for the municipally important groundwater recharge areas. That map was reviewed by the board. We forwarded that to Highlands for their review to determine if they agreed with our mapping. Essentially, toward the end of last week, we got back from them and some information that said that essentially they agree, but not quite. And where they disagreed was one of the parcels that we were concerned about having the groundwater recharge mapping over top of was the municipal park at the base of the high school. And they came back with a recommendation that that whole area be incorporated into a groundwater recharge area. We suggested that that was not a very good idea and that we wanted to discuss that with them further. And so we're scheduled for a conference call. Paul's going to be involved, Adam's going to be involved, for this Thursday at 3 to discuss that one item. Assuming we can get that resolved, which we probably can, we would then basically move for the board's consideration of the map, the amendment of the township master plan to incorporate it into the township plan. In addition, one of the things that the Highland has brought up, and I'll be honest with you, I didn't recall this when we first discussed it with them, is that they also want us to consider enabling legislation which would be submitted to council that would actually put some teeth in the regulation in the sense that it would impose the design criteria that the Highlands would like to see only within the area of the groundwater recharge. It wouldn't apply to the whole township, but to specific areas. And my reaction to that is that if the map that we all reviewed and approved eventually ends up being the document, though it adds an additional step to this, I don't think it'll really result in anything that we did not expect. In other words, I don't think it'll be infringing on things or causing difficulties that we had not perceived. If we end up getting the map fully approved, all the lands within the town center designation will not fall within this. So it will not affect the industrial areas, the commercial areas, or the residential areas that are within the town center. So that's where we are. I'll have a better sense on Thursday where we're headed with that. They clearly understand our concerns, and I'm optimistic that we'll figure some way around this thing.
Mr. Chairman, can I ask George a question? The parcel that's under dispute, is that in the park or is it on the school property or both?
It's basically, well, it's basically the park. I don't know the exact line between the school and the park. The school obviously is not in, and our original recommendation to them was to include all the land and from the school all the way down to the highway, to take it out of that. They came back and said, no, that's too much, we can't take it out. We then recommended that we split it. Well, in discussions with Paul, we were going to include a certain piece in, but keep the main park area out. And that's what went back to them, and they said that wasn't enough. So that's why we're having the call on Thursday. I don't know where the line is exactly between the two. The intent was not to have the school or any of the township park area affected over there.
Well, how does this affect us? If we want to expand the snack bar or something like that, we encounter another layer of regulation?
Well, that's the thing we were just trying to
Yeah.
avoid. The regulation could, depending on what you want to do, have an impact, because obviously it regulates disturbance, total impervious cover. So on a particular case, it might be a problem, other cases it may not. But one of our concerns, or at least mine, and I know Paul had others because he knows some of the long-term plans that the town has, is simply, since it regulates disturbance, theoretically, even building a ball field, even though you're not putting any impervious cover down, doing anything, that could trigger a review because of
Well, here's my
disturbance.
concern, I think the mayor probably shares this. We have this plan, I'm not sure when we'll see it, but we were talking about a master plan, bringing in a park planner and doing a master plan for the park. And it has needs. And we don't know what that's gonna look like yet.
Yep.
And it's my concern right now. It is a park. That's what it's there for.
Yes,
Yeah,
and that's why, I mean, I'm sure that that's one of the reasons Paul is concerned. He knows your long-term plans, and also, our goal was to try to have no overlapping regulations there.
Yeah.
Essentially, you'd be free to do what you could do under the existing township zoning and the school without interference. And that's where we hope we'll be at the end of Thursday.
George, you don't have a map of anything? I mean, I know there's a wetland area there.
Well, we do have a map. I didn't bring it along. Did you?
I printed it out, yeah.
Yeah, there's a map.
I mean, this is a very small scale map, but this is the
Yeah,
map
it's really hard to...
that they finally came up with. It's basically everything up to the school, looks like up to the school line, potentially.
Right, the one that they propose includes all the ball fields, everything right up to the base of the
This is
school.
park. And I think they excluded the area around the pool probably, but everything else, all the other fields
Are all in it.
up to the school property line looks like are in it.
And they did submit a map to us that shows the sensitivity to infiltration in that area. But that really isn't the issue, because they supposedly have a model that averages out the infiltration and what they want. So it's spread over a whole watershed, so it's very hard to look at one piece of ground and have a clue what your impact is on their model. And
What they do is they weight the deficit in groundwater
Yeah.
recharge. So if an area is lacking in recharge, they list that it's in a deficit area, so it needs more recharge. And then the ordinance that George referenced, we've adopted in some other municipalities, require a higher groundwater recharge percentage than what's currently in the ordinance. That's their Highlands. I think it's 25% or 50% increase in the groundwater recharge you'd normally see under the current ordinance. Now, the other thing that comes into play is the fact that the entire town is underlain by karst, so we don't get into groundwater recharge and infiltration, and Highlands frequently in their consistency determinations understands that and doesn't require groundwater recharge. So we're like talking in circles, because the goal of the Highlands is to increase the quality of water in the state, but in Lopatcong specifically, they frequently grant waivers from the requirement for groundwater recharge because you'd have sinkholes instead of detention basins and infiltration basins. So, again, as George said, we're going to talk to them tomorrow and see what we come up with.
Yeah, Crick, if you look at this map, all right, it's engulfing the pool, field above it, and the pavilion are open. It starts at the parking lot and comes down to the ball field, the junior field they call it, the main one, and shoots straight up for us. And then it goes all the way over to the quads, all right, and goes straight on up through there. That little opening right there is where it's a privately owned home. That's
yeah, in the center, the little rectangle, yeah.
So
It's right up to
basically, our whole
residential
upper
properties
parking lot, or the
along
whole upper
Belvedere
park,
Road.
the new part of the park, if you want to call it, is locked. So that needs to somehow for us to be able to do.
Well, the other thing is, under their definition of impervious, I mean, a basic infield with an infield mixture would
Yeah.
be impervious.
Yeah, compacted
You-
gravel.
Yeah, almost anything that impedes the inflow, yes.
And it also regulates the disturbance, so your thresholds are a lot lower.
The other thing is, where's the logic where the high school's ball fields are excluded and our ball fields are included? I don't get it.
Well, the logic there was simply anything that was developed is excluded. So, I mean, bottom line is they were there before they did the study, therefore they went around everything. And the other thing they did, which in some sense probably made sense, is their tendency was to incorporate parkland and preserved land as protection area, because their thought is well, nothing's going to happen there, or very little. It just happens that in this case they want to put the major township park under their, under this jurisdiction.
Well, that's faulty logic. I mean, parks, trails get developed. I mean, it happens all the time.
Yes.
Well, look, George, you hear our concerns.
Yes, and I know your concerns, and that's in the map that we had put together, essentially, the one that went up there, they agreed to everything in the map except this park piece is what they came back with, and so that's where we are.
That's our future, is our town. As it grows, that's where the people are gonna go. They just locked us and said stagnate.
Well,
That's how important that park is to the development.
No, I understand. It's your best park facility. So everybody knows that, and so does the Highlands. So we'll see what comes of it on Thursday, tomorrow.
Okay. So, board's aware of it. Rich and Adam will be acting with the Highlands project.
Yes, and as I said, Paul's in there, so he'll bring his understanding of what's going on and also where the property lines are, because Paul gave us the original map of what should be excluded. And we even excluded more in the original submission. We went up the hill and...
George, the other thought I have, if I recall, we were deeded a substantial amount of acreage north of Scenic Ridge, roughly half that property. Is that in this preservation area, or can we swap that for something, or?
Scenic Ridge, is that in?
Adam, you know what I'm talking about, right?
That's the problem with that.
I'm not entirely sure.
Goes way back to when we did the land swap to make this park happen.
That's correct.
And Scenic Ridge had a large parcel, and they developed half of it, deeded the other half to the township.
I'm not sure. I'll have to look at the map. I'm not sure exactly. On this scale, it's really hard to see, but the pink is the area that...
Right.
Right here.
So which parcel is
So,
deeded?
this is where the homes are. This is right here. I don't know
So
if
that's all in there, so
That's
that's,
what-
That's all in
so
already.
that's all in
Most
right
of
now.
it's in it, Joe.
It's in right now. They probably identified those preserved, there was some preserved open space, and they probably included those.
Right. And you can see in there, you can see the land even where between the development goes up to a cul-de-sac and it goes up to another cul-de-sac. You can see the runs, where the
Yeah,
trees are.
separated.
It's
Yeah,
out
the problem is, I don't think we ever designated it as anything. It was just deeded to us, and it sits there. So nobody,
So what wasn't ever there's no conservation easement on it or
no,
anything?
no, it's not. So,
But they
I would
included
object
it.
to that too. If we have to swap it for something,
They probably
maybe
looked
we
at
can, but I-
municipal parcels, included municipal
Yeah.
parcels in it.
Yeah, as part of this study, the first part of this study, we went back and identified all the preserved lands, all the parks in town, updated all their maps for developed parcels. They got that as part of this study. Before they generated this map.
dig your heels in, George.
Well, no, we understand exactly, and then we made it very clear when we sent back the map and said, no, we have to find a solution to this. We and obviously Paul and Adam, we all know what the town wants up there, so we'll find a solution that keeps that open.
Any further discussion on the subject? Seeing none, we can move on to... Well, we remind the board members that your financial disclosure filing is due by the 30th of April. Doesn't give you much more time if you haven't filed yet. You file online with that, you go directly to...
You can stop in the office if you need assistance. I'm glad to help.
Okay.
Remember that, Ian?
Okay. Public comment? John, do you have anything, or? Okay. In that case, we're at the, oh, I'm sorry, Kathy?
I do, under public comment. Tonight when I was driving here, I noticed that our Lopatcong convenience store is closing, and big sign up was going to be an In-N-Out Burger. And I was wondering how that would affect zoning, building permits, whatever. Changing it from a convenience store to a fast food drive-through.
I don't think that's the intent of that. I believe the gentleman that was there before, that moved down to the current Lopatcong convenience store, is going back up there May 1st.
Oh, there's
That's what I've heard.
a sign that says, big sign tonight, first time I've ever seen it, big sign on the window, In-N-Out Burger coming. And from the time I've spent on the West Coast, I know the In-N-Out Burgers. You got it.
I didn't know they were coming to the East Coast.
Yeah, it's kind of,
Never heard that,
big
yeah,
deal,
never heard
big
that.
deal in California.
Yeah?
Trust me, you don't want to hear of it.
Was it like a White Castle?
It's like the best,
That's better.
the best
No,
burger in California.
That doesn't belong in the minutes. I think it's better than Castle, but
It's greasy, okay?
It's actually not very good.
So is Toby's.
Like I said, they're all over Reno, come on.
It's
guys.
greasy.
but it's not, the point is, it's not a convenience store.
Exactly.
It's a different operation.
I haven't heard of an application. I don't know if George has.
No, I have not.
So, or Beth has seen anything.
Oh, no, I haven't heard
So,
anything.
yeah.
Do we just ignore it?
Zoning official.
No, they can't. Well, no, I don't know if you ignore it. That's not what I heard. but-
Well, he'll need
Just go look at the sign.
He'll need a building permit to do anything there, and he'll need a zoning permit before the building permit. So we just gotta make sure,
We'll probably need site plan approval.
And In-N-Out's gonna be a little more, if it is an In-N-Out, it's gonna be a lot more use than, than a convenience store.
No, I know them from the West, I spent a lot of time.
Sure it's not a building behind it?
I don't know.
The warehouse behind it?
I believe so.
Yeah, it's gonna be,
You're gonna have traffic.
Because we haven't seen any.
it's gonna be worse than Chick-fil-A. I'm saying busier, not worse tasting, busier.
You're on record.
I'm on
That's right.
It's gonna be busier than
You're on
Chick-fil-A.
record now, sorry.
It's gonna be a quote we can take out of context.
I actually love White Castle, I didn't mean to denigrate it.
I do as well, Mr. Pryor. It's good.
I think we're getting a little bit far fetched for being on the record. Shall we
Keep on going on this.
entertain a motion to adjourn?
Motion.
Do I hear a second?
Just before everybody terminates, I left everybody a memorandum
Yes, I see it.
on the dais. It's just about conflicts of interest, a new case.
Yeah, I saw that.
More murky, more difficult, more of a sliding scale where you don't know exactly where to call it, neither do the judges. So, just be mindful of conflicts of interest. Take a look. If anybody has any questions, let me know.
Okay.
Keep it with your ethics, rules and regulations for the planning board.
You have to ask.
Okay. All those in favor of adjourning? Any opposed? Any abstentions? Okay, we are adjourned.